The cross-examination of Lieutenant General Shadrack Sibiya produced patterns between himself, Sgt Nkosi, who is also known as Witness F, and Vusimuzi Matlala, which do not favor Sibiya's bid to distance himself from any association with alleged cartel members. And the alleged rot in the city of Ekurhuleni reared its ugly head again as a third part of the puzzle in the alleged shield afforded to Commissioner Julius Mkhwanazi, that is Mrs. Linda Kasha, took the stand. I'm Kani Mapanga, and this is the Madlanga Wrap.
You are upfront alerting Mr. Matlala through Sgt Nkosi. You are basically saying, hey, be aware, there's trouble brewing.
I'm very worried about the evidence leader because she selectively chooses portions that she thinks only address that what she wants to achieve. Deliberately choosing to ignore the fact that Mr. Matlala raised an issue and said, I have a problem with this recording. This is not my voice. It was AI generated. As we speak, I'm at war fighting for my career now.
The cross-examination of suspended Deputy National Commissioner for Crime Detection, that is Lieutenant General Shadrack Sibiya, saw evidence leader Advocate Adila Hassim SC go through various events in forensic detail to show that despite his denials, there is some form of an alleged relationship between Sibiya and alleged cartel member Vusimuzi Matlala. One of the many examples is the fact that Sibiya sent a confidential audit report which flagged the contract of Matlala to Sgt Nkosi. That same report landed in the hands of Matlala, but Sibiya wants the Commission to believe that he had no intention of seeing that report land in Cat's hands, despite patterns showing that Nkosi was always the middle person in the alleged engagements between Sibiya and Matlala.
You were basically sharing, and I suggest this to you, you were basically sharing with Sgt Nkosi to alert Mr. Matlala as to what was happening. And what was happening, with hindsight now, eventually resulted in the cancellation of the contract. So you are upfront alerting Mr. Matlala through Sgt Nkosi. You are basically saying, hey, be aware, there's trouble brewing. That is what I'm suggesting to you.
Again, that pattern of an alleged link between the two in the Impala saga, where it is clear that Kat texted through Sgt Nkosi regarding the delivery of the Impalas. Further evidence showed that there were Impalas on Sibiya's property. When confronted with this evidence, Sibiya introduced additional issues and denied receiving any Impalas from Matlala, and went to the extent of claiming that he, as a high-ranking SABC official, was of no value to Kat, a claim that was quickly corrected by the Commission's bench.
I never asked Mr. Nkosi to approach Mr. Matlala. I didn't know who and how was Mr. Nkosi going to assist me in getting such. Secondly, I am categorically denying that I ever received any such delivery from Mr. Matlala's side or from Nkosi's side, because I didn't need them at that time. Now, I'm saying also that I am not saying what I'm saying because I'm being asked questions. I don't want to get or be pushed into a corner of saying, yeah, you knew it comes from Matlala. I had nothing that I've assisted Matlala with, nothing that I worked with him on, and he had no reason to give me anything because I have never assisted him. I don't think he would invest in a dead horse, because having to do with the tenders is supply chain, and I'm far from the supply chain, so I wouldn't be of any value to him. With regard to whatever that was happening in his investigations, it was being handled in the province. So I'm just saying, to me, I had no real-time dealings with Matlala that could lead me to interact in such a way that he can give me something. That's what I wanted to say.
General, let me correct one thing. Mr. Matlala would not have asked for a meeting with you, and he would not have made an effort to meet with you in January 2024 if you had nothing useful to provide to him. The reason you said so yourself, he came to you, is because he sought your assistance or intervention. That's the real reason for the meeting in January 2024. Yes. He sought your assistance or intervention. And a month and a half later, there's the issue of impalas. So you are not correct when you say you had nothing to offer him because issues of tenders were supply chain issues. He came to you in relation to issues of tenders because he thought you could assist him. He was not wasting his time when he came to your office in January 2024.
Now, Sabia, who was seemingly fatigued with the long exercise of cross-examination where he faced the task of answering questions in the face of evidence that showed patterns that did not favor his position. Sabia further raised the issue of fairness and prejudice, taking an issue with the fact that he had to answer to the text messages of another individual and that he could not answer adequately as his devices, which hold the necessary information according to him, were taken from him, prompting questions of whether Sabia can in future raise that he was prejudiced in this process and that he was not offered an opportunity to give his evidence. To unpack this question, we are joined by legal analyst, that is Ulrich Roux of Ulrich Roux and Associates. Ulrich, thank you so much for your patience amid that developing news in the Middle East. So much to talk about, though, in our domestic issues, and it seems that Sabia is raising an important point, which I think will come up a lot for the phase 2 witnesses who are implicated, and they're raising these procedural issues of fairness, getting documents at a late stage, and then, of course, being prejudiced by not being able to give their full version in that short period in which they appear. How much merit do those claims hold in the long term following the work of the Commission and the subsequent report that we expect?
Well, the testimony of any witness before the Commission must be procedurally fair, and the witness must be given an opportunity to adequately answer the questions that are leveled against him. Having said that, if he, complains that he has not had sight of certain text messages on someone else's device, then it would be prudent for the evidence leaders to print out those messages and the text messages that are referred to, and to hand a copy of those to the witness in order for the witness to adequately look at the text messages and to adequately answer questions pertaining to it. Now, this is the job of the Commission and the 3 leaders of the Commission or the panel in order to determine whether the testimony that is being led is procedurally fair and whether the witness is given a fair opportunity to adequately prepare and answer questions leveled against him. Remember that this is not a criminal trial. It is a commission of inquiry, and therefore the normal rules of evidence do not apply as they would in a criminal trial, but certainly, certain weight can be attached to evidence, and it's in the interest of all parties involved for the commission to be conducted fairly and procedurally in a fair manner. So, in my view, if the evidence leaders want him to address certain text messages and he claims that he is not allowed to see them, but now he must answer thereto, then a copy of those text messages must be given to the witness in order for him to adequately answer.
Speaking on that, in the context of witness F essentially being the alleged middleman, so he would carry the messages between the two, or at least that's what the evidence suggests. Does this claim or issue being raised by Sabia in any way negate what the Commission was already able to extract from the phone of Sgt Nkosi, which shows communications between Nkosi with Matlala and with Sabia that are directly relevant to the work of the Commission and paint certain patterns about Sabia? So they don't have the messages from Sabia's phone, but they do have this individual's messages that claim to be the alleged middleman or common denominator. Does that in any way negate what they already have before the probe?
No, I don't think so. I think what would be of interest is how he answers to the allegations leveled against him pertaining to those text messages. On one of the excerpts, he claims that they are AI generated and that he has no knowledge of it. Well, he must substantiate that and he must back it up. Now, the only way to do that is to obviously disclose his own telephone and to show whether those text messages are indeed AI generated and whether they are in fact on his phone and what weight can be attached to those messages. So no, in short, I don't think it does negate from that. I think that the allegation has been made. And I think that the evidence leaders have demonstrated that. So, he should rather take the commission into his confidence and answer that directly than to make claims of AI generation, etc.
Speaking of that, he was actually referring to Witness C's recording where Kat Matlala, after his arrest, actually implicated him in the Impala saga. And he questions the authenticity or credibility of the recording because it didn't go through those forensic tests. I was actually going to ask if he's not applying a higher threshold to that particular material before the commission.
No, once again, this is not a criminal trial, so the normal rules of evidence do not apply here. And one must look at this on a balance of probabilities and what weight can be attached to the evidence. So, again, it's in the general's interest to take the commission into his confidence and to present his version if he claims that the version that has been presented against him is not true. But certain weight will be attached to evidence when the report is finally furnished. So again, the best advice that one could give to him is to be open and transparent pertaining to his testimony.
And lastly, very quickly, Ulrich, we're seeing some witnesses relying on sick notes to evade their testimony. And the last witness that relied on this to give a postponement bid, actually there was conversation about possibly bringing doctors to testify on those sick notes or medical certificates that they issue out to the witnesses. What are the legalities surrounding this if the commission were to implement that?
Well, each alleged sick note and each excuse by a witness not to be able to testify must be evaluated on its own merits, and that is done by the evidence leaders and by the commission itself. The commission does have the power to issue subpoenas for witnesses to appear, and ultimately it also does have the power to issue warrants of arrest, etc. So, if the commission finds that a sick note is not, in fact, authentic and it is not, cannot be accepted by the commission, and they could very well issue subpoenas for those doctors to come and testify. Alternatively, issue subpoenas for the witnesses if they still refuse. Then issue a warrant of arrest or bring an application for that person's incarceration. We saw what happened to Jacob Zuma when he refused to testify. So, people should take it very seriously and should definitely only present valid sick notes if they are indeed sick and if there is a valid medical certificate to prove that.
All right, Ulrich, we thank you so much for your time. We have run out of time. That was Ulrich of Ulrich Roux and Associates reflecting on that particular testimony with respect to the issues of fairness and prejudice, as well as the issue of sick notes that may possibly become a trend before the probe as phase 2 witnesses seemingly try to evade their testimony. Now, suspended Ekurhuleni HR boss Linda Kasha took to the stand this week and denied allegations that she was part of a shield that protected suspended EMPD Deputy Police Chief, Commissioner Julius Mkhwanazi, from accountability. Kasha and her evidence in chief instead shifted the blame to her accusers, alleging that they failed to act on Mkhwanazi. That's despite evidence suggesting that obstacles were formed in the Ekurhuleni's top management, which effectively stripped the powers of Chief Mapiyeye and Xolani Ngciza and effectively halted the DC of J. Mkhwanazi amid a slew of allegations ranging from the Blue Light saga to murder.
Thank you, Chair. Firstly, I would like to, as stated in my statement, I refute the allegations that I have supported and participated in the usurpation of the powers of the Chief Executive Officer, and I think the Executive Head as well, in terms of the Section 64C of SAPS Act. And the reason is that, Chair, maybe I must explain that. Firstly, a premise in my submission is of the fact that the city manager, municipal manager, the CEO, is the ultimate authority on all matters relating to municipality, and specifically, in this instance, the municipal police service, as per Section 64B. I think for us to focus on Section 64C it won't be proper. It must be read in its entirety, but with also section 64B, because the ultimate powers, they start there.
Now, despite her denials to the allegations, Kasha struggled to point to tangible steps she took to discipline James Nkosi. Instead, what emerged is that Nkosi was not disciplined, but in fact his suspension expired and he was rewarded with a promotion under her watch. Kasha attempted to rationalize her actions by raising the principle that one is presumed innocent before proven guilty.
I want to suggest to you that it's not available to you or open to you to rely on that principle of innocent until proven guilty if you contributed to the disciplinary hearing not happening. It's not open to you. You can't have it both ways. You can't agree with the frustration of a disciplinary process and then later on rely on that it didn't happen and say, well, I couldn't hold it against him.
While Kasha made some concessions and admitted that she could have handled the James Nkosi matter differently, the damage is already done. Her role in the failure to discipline James Nkosi had far-reaching consequences. James Nkosi was able to run an alleged parallel structure within the city that allegedly included elements of crime that negatively impacted citizens of Ekurhuleni, ranging from truck theft to even murder. And now questions remain on whether justice will prevail following James Nkonsi's alleged reign of terror. This brings us to the end of this week's Madlanga Wrap. Join us next week, same time, same place, for more analysis on this all-important probe.